Hello, everyone. Welcome to the first installment of the Prosecution Foundation's webinar series, Educating the Judge and Jury on the Realities of Human Trafficking. Next slide, please. My name is Shay Smith, and I'm a project associate on the anti-human trafficking team at the International Association of Chiefs of Police. Before we begin, I'd like to go over a few quick details. For technical support on this webinar, please contact Callie Fry by email or chat. For best quality, we suggest you close all other windows on your computer during the presentation. Today's webinar will be recorded and will be made available on IACP Learn, IACP's online learning platform. Also, after the webinar, you'll be provided with a short evaluation. We hope to receive your feedback so we can learn more about your experience and how we can continue to improve future events. You can submit questions through the chat box at any time during the presentation. To send a question or a chat, use the chat box at the bottom of your screen. There will also be time for questions at the end of the presentation. Next slide. This webinar is supported through a cooperative agreement with the U.S. Department of Justice Office for Victims of Crime. Since 2015, through the support of the Department of Justice, IACP has provided a broad range of training and technical assistance, such as this webinar, to forward the mission and vision of the Department of Justice in combating human trafficking in the United States. Today's webinar is hosted by IACP in collaboration with our speakers from AEquitas, who we will introduce in just a moment. IACP is the largest and most influential association for police leaders in the world, with over 33,000 members in 173 countries. The IACP has been serving communities worldwide by speaking out on behalf of law enforcement and advancing leadership and professionalism in policing worldwide since 1893. This webinar is provided as a part of the U.S. Department of Justice Office for Victims of Crime Enhanced Collaborative Model to Combat Human Trafficking program. The ECM program, as it is known for short, is comprised of multidisciplinary and collaborative partnerships that include police, prosecutors, victim service providers, and an array of community stakeholders. The ECM program develops and expands capacity of multidisciplinary anti-human trafficking task forces to identify victims, provide comprehensive support services, and hold traffickers accountable. The ECM program requires human trafficking task forces to implement collaborative, sustainable approaches to investigation and prosecution that are trauma-informed, victim-centered, and seek to proactively identify and serve all victims of all types of human trafficking. Next slide. Through the support of OVC, IACP provides several services and resources, such as an online library of publications and tools, webinars and online trainings, in-classroom trainings, and a variety of customized technical assistance programs for enhanced collaborative model grantees. IACP is just one of several OVC-funded anti-human trafficking training and technical assistance providers. You can find out more information about our fellow TTA providers by visiting OVC's website, which we'll put in the chat. I will now pass it back to Jane Anderson with AEquitas.
Thank you, Shay. Welcome, everyone. I hope you guys are not on too much of like a Candy Crush letdown. I put in the chat just a couple of questions to have you guys introduce yourselves. We're really excited to start this series. This is the first of what we hope to be many conversations about trauma-informed practices when it comes to prosecuting cases involving human trafficking. And this first conversation, not only am I excited to have it because we're kicking it off, I love the topic, which is how to better educate judges and juries about the realities of trafficking, but also because I'm going to have my guest expert today, Miiko Anderson. She's our newest hire at AEquitas, and we're so thrilled to have her join our team. Miiko and I have known each other for a couple of years now, actually, and we'll maybe tell you guys the story, through her use of experts in a really creative and effective way when she was prosecuting cases in Fresno, California. And then over the years, we continue to stay in touch, and then the right timing happened. So Miiko joined us. I know a lot of you have heard me speak before, so I won't go into too much of a detail. I really want to host this conversation more than anything else but I am a senior attorney advisor with AEquitas. Prior to joining AEquitas, I was a prosecutor in Miami-Dade, Florida. Welcome to anyone from Florida out there. And I started my career handling domestic violence cases, misdemeanor level, and then worked my way through the office before in about 2010, we started looking at trafficking on a state level. And I was lucky enough to be a part of co-founding what eventually became a standalone human trafficking unit. So now I use that experience to hopefully help you guys in the field. And one of the ways to do that, we thought, was to have this conversation about this really important and key piece of being an effective and trauma-informed prosecutor, which is education. So AEquitas, I'm going to give a little bit of blurb about that, and then I'm going to have Miiko introduce herself. Hopefully you guys are familiar with AEquitas. We're funded through various federal and private grants to support you and the work that you do. So most of our consultations and our trainings and our technical assistance is free to the field. And if your work intersects with the criminal justice system on issues such as intimate partner violence, sexual assault, stalking, sex or labor trafficking, we're here to help. And hopefully we can provide you with really innovative and informed strategies, but most of all, practical strategies that you can go ahead and implement almost, immediately when you go back to your offices. So without further ado, my guest expert today is my new colleague, and hopefully we can say friends at this point, Miiko Anderson. Miiko, if you don't mind introducing yourself a little bit.
Sure, and we absolutely can say friends at this point. Hi, everybody. My name is Miiko Anderson, and we could almost say family members only because of our last names, although we are not related. And before I get started on my introduction, I did want to clear up my response to the Halloween candy question in the chat. I noted that I like everything chocolate, and then I put from California. So I like everything chocolate from anywhere. I am from California, so just in case there was any confusion. And as Jane said, I am recently retired from the prosecution office here in Fresno, California, where I was a senior prosecuting attorney for a little over 16 years. And in my time there, I worked the majority of my time in domestic violence, sexual assault, human trafficking, and gang violence prosecutions. So those were was that the bulk of all my assignments there. And while there, for the human trafficking piece, I was the founding and solely assigned senior prosecuting attorney for our human trafficking unit, and then we formed our human trafficking task force there, where we really started to concentrate and focus on prosecuting human trafficking crimes. And that happened in about 2016, 2017, I believe. And I also work with a nonprofit agency here in Central Valley. And it's one that's dedicated to providing comprehensive services for human trafficking victims. And so that's kind of my area of law. And for many years, one of the biggest difficulties that we had with these type of cases, which I'm sure a lot of people may be able to attest to, is proving these cases when there were, complex issues at play. Maybe it was an unavailability of a witness, or maybe there was some stereotype or bias that you felt you had to overcome. And it made it really important to be resourceful and really important to know who to lean on when it came to being successful in the prosecution of these cases. And so that's why the topic of this podcast is so important, because the expert testimony can really cover some of the gaps that we might need to fill. And so now that I'm very new at AEquitas, I've been here since, I'm going on 3 months though, been here 3 months, although I have experience because we've worked independently or separately on different training endeavors. I'm very excited because one of the benefits, I think, is that it does the deep dive into stuff that's really practical and what you can do. Because I know, as far as in my jurisdiction, we had a lot of difficulty, not just with the casework, but because of labor shortages and not having as much time for training, that you didn't necessarily have a lot of time for fluff. That's why I'm really excited that this this is the first of many, but will be conversational and will focus on the practical things that we need to be able to be successful.
Yeah. And we're going to kind of start with this big picture of like why it's so important. And I was reminded the other day because I made the mistake, and I try to avoid it at all costs, but I made the mistake of telling somebody a little bit of what I do for a living. And I mentioned human trafficking, and still to this day, um, the immediate question was like, where are they coming from? Are they coming in cargo ships? And I have to remind myself because, we're doing this work and we're hanging out with each other and other people in this profession. And we sometimes forget that not everyone knows like what the reality of it is and what's like the impact of that. So Miiko, I'll throw this out to you, and you kind of keyed into it already, but like, why is this like the most important thing that we have to make sure we're prepared to do when we go into that courtroom?
Education of the judge and jury to the realities is hugely important. And it's just like you said, a lot of times when you're in the world of it, you get educated to a higher level, and sometimes you mistakenly forget that others haven't. And the role of the judge and jury is so important to the success of the case. It requires that you take the time to really do like inclusive education. So education from a bunch of different aspects. And one of the things that I found is sometimes surprising, but very common, the misconceptions and myths that are out there that still live, and you think that that's so old and antiquated, nobody really believes that anymore. But it really is a lot more prevalent to have those myths and misconceptions be present. And I guess in my mind, it's because of like the um, presence of social media or some other mainstream media where they may promote one particular very narrow sliver of what human trafficking looks like. And because that very narrow sliver is promoted at great proportion, has a great presence in all these different media streams, people think that that's the only way it can appear. Or something like as simple as fear, everybody kind of gets the idea that fear is something that's present in these cases, but not really recognizing that fear presents very differently from person to person, case to case. And sometimes you have to stop and make sure that everybody is aware of that so you can go forward.
Yeah. I'm curious for you guys that are listening, what are the topics that you think need to be overcome just generally about human trafficking cases? Because I still to this day, we'll call it the taken effect. Like, okay, these are the expectations, this is the reality. And when they're so far apart, that just means we have so much more work to do to get the jury to understand what's going on. I sometimes joke that if you've got a kidnapping case and it involves a white windowless van, you're good to go. But if the kidnapping had any other vehicle involved, you better be prepared to explain it. And so that's like where I think we need to start. So what are some of those like realities of trafficking that you want to make sure like every judge and jury understands going into these types of cases? And Tiffany was like right off the bat, was like, jurors don't understand coercion and they don't understand psychological harm. And I think that goes a little bit into what you were saying about how do these things like present themselves? How do we articulate those to our judge and jury? Mary's talking about the fact that an individual may begin working voluntarily and then things can change and it can turn into trafficking. And I think we've all probably had a case and spoken to survivors who explain that not every situation when there's commercial sex is trafficking. And it's not one or the other either. There's sometimes it goes back and forth depending on the situation. There's no such thing as a perfect victim, of course, different than the media portrays. And then sort of these complex dynamics of forced criminality, maybe complicity or culpability. I think those are like super, super advanced in my world. Sometimes I feel like we're still having to deal with like making sure they're not thinking about smuggling when they're thinking about trafficking, right? And where you are, Miiko, I think there is Central Valley, there's like a lot of migrant workers and things like that, right? So does everyone tie that together with like smuggling and trafficking?
They do. That can be a popular misconception and think that you have to have smuggling in order for it to be trafficking. They think they're so closely related. So there's a lot of those same misconceptions, and a lot of times too, the stereotypes and biases that they may have against certain victims. Like, well, I think somebody in the chat said that the person may not appear to be a victim. A lot of times in cases that we've had where there was some voluntary quote unquote wrongdoing, and it may not have been the trafficking, but some action that someone might think is a wrongdoing, um, does not mean that everything that happened after that is somehow negated by some small act. So just explaining really what trafficking really is and what the purpose of it is.
Yeah, I remember early days, like this idea of like trafficking and and maybe we have to like maybe we didn't do ourselves any favors when we used the word trafficking, but I was like, there's no transportation involved, right?
Sure.
This is not about a traffic jam. Like it does. So I would say this is about exploitation, not transportation. That was something that I kind of made sure that jurors kind of could get. And we started doing that in voir dire. But really like the commonality of nonviolent means of control. Really sometimes that all types of individuals, there's definitely folks out there that I've accidentally mentioned what I do for a living to in a, on a plane or somewhere, and they're like thinking it's all foreign nationals. They don't think it can be US citizens that are being trafficked. So these are, I think, some of the really basic things we need to get to. And then we go into some of the more complex dynamics as well. So how do you, Miiko, because I know you've used experts and maybe you can talk about a specific example of what prompted you to do it for the first time, but how do you look at a case that has these complex dynamics and maybe something like forced criminality or somebody that was doing something voluntarily at some point and trafficked at other points, some of these harder things? How do you look at your case and figure out, okay, this is what I need to explain and how I want to explain it to the judge or the jury?
One of the first things that I think I do that help me recognize that is that I have conversations and like educational sessions with the public generally. And of course you do it because you want to raise the level of awareness and you want to, be able to, do prevention and have everybody be aware of red flags. But one of the benefits of that is that you really get keyed in, at least for me, really get keyed in to what some of the misconceptions are, like down to like a detailed level. When you have the conversation that's not related to a case, right? You have the conversation, just general education purposes, and you see where people start to have difficulties understanding things, and it makes you better able to articulate why this is trafficking, why this is a reality, why this is not voluntary. So you're not confronting it for the very first time when you see it in your case, and you kind of know like the temperature, if you will, of like your area, right? Every area may be different. Some people may have different facts that may mean more or less, but really working with the public outside of the case really helps you kind of keen in on some of those things. But when it comes to the actual case itself, for me, when I am looking at a case, I kind of just go through it and I highlight there are some things that you kind of know that may be difficult, and I just don't take anything for granted. I just don't assume that just because I understand that it may appear to be this, but it really is this. I just cover it to on a like very simplistic level. It doesn't even have to be very complicated.
I love that idea of almost using those awareness opportunities that you're having with the public as like a practice session. Like, okay, if I can explain this in a way that, Joe Schmo from the Rotary Club, no shame on that, can get it, then I can explain it to the jury, and I can
Right.
see what like kind of hits. And I think a lot of us do that when we're thinking about jury selection in all of our cases, is like, who has that sort of neutral sounding board that is not an attorney, not a prosecutor, but like a friend that has a totally different career that you can kind of throw things at and be like, okay, what if I explained it this way? What if I talk about it this way? And you kind of like practice what hits. And then to be thinking about, like, don't take anything for granted. Because I feel like we do. Like things like delayed disclosure, I'm like, whatever, everybody gets that now. And they don't.
Right.
So tell us how now, had you been using experts in other types of cases before you started doing trafficking?
Yes, I used experts in domestic violence cases and in gang cases. So I was familiar with the use of experts. So we had them in both of those areas.
No. Okay. And I do think that in trafficking cases, especially now, because we just don't have that general education, that expert witness testimony is really so key. And we're going to hone in on that. But, there's other ways to start that education. And so I kind of wanted us to walk through like the other tools that we have. And I was looking at this and I was thinking, oh, we could even add in here like pre-trial motions, because through pre-trial motions, we can start educating the judge about some of those issues as well, just like how we talk about it, what types of arguments we're making, whether that's like a rape shield argument, or in a labor trafficking case, it might be about the admissibility of immigration relief, or there's all these kinds of pretrial motions that we can start to educate through. But then when we're talking about really in front of at trial, the jury selection, and this really varies like jurisdiction to jurisdiction, like how much you're going to be able to talk about it. But I'm wondering, how did you start kind of laying that groundwork when you were picking a jury?
And for that, I would first agree with you on a pretrial motion piece, because sometimes the issues can either be so nuanced that you want to give your judge time to maybe research it. Maybe she needs to, take a longer time reading that material. So you want to be able to have that. When it comes to jury selection, for me, I did it conversationally because I'm a pretty casual kind of person. So I did it conversationally, and that's why working with the public and those awareness events and all those kind of things really help, because some of the issues, especially when it comes to things like bias and stereotypes and race and somebody's lifestyle appearing different than your own, those kind of things, it's difficult to like anybody who's being asked that is not going to say, yeah, I am racist. So I will not, you're not going to get that. But to be able to have those discussions and try to figure out, what somebody's true opinions and beliefs are, and if they can set them aside, is always better when you have practiced some of those really difficult questions in a way that you can pose it that's not like judgmental at whatever their response is, because you want them to be more forthcoming. So that's kind of like the tone that I set, to be as conversational, as relaxed, and try not to be surprised by some of the, or not show the surprise by some of the answers. And then because the motion to eliminate, when I submit the motions, pretrial motions, pretty much outline some of the facts that I thought were probably the ones that made me really want to address to the jury. That I use that sometimes as a guide, just to introduce those to the jury so that they can get familiar and see if that alone is enough that would prevent them from being fair and impartial when it came to this kind of case.
Yeah, and I think this is something for those of you that might be maybe about to try your own case, or you've got a case. This is something that AEquitas really can help you guys out with, because we can do a one-on-one consultation where you can really tell us like, okay, this is how jury selection works. like with this judge in this courthouse, in this county, in this state, because there's so much variety. I was like you, Miiko, I was allowed to have quite good conversations with the prospective jurors, and I also kind of have that conversational style. So like I wanted to really set the tone, and so I would start having conversations about vulnerable people in our communities, like always like in our community who's vulnerable. And I would get, the jurors to kind of come up with, of course, women and children were always like the first things that they would say, and then we'd maybe get into a little bit more deeper into like who else might be vulnerable, and they might be, oh well, somebody that is homeless might be vulnerable, or somebody that has a disability, or somebody that has a substance use, or somebody that's undocumented. And then we're really focusing on that vulnerability part, which then allowed me like a better opportunity to set the stage that this trafficking is really about the exploitation of vulnerabilities, and like kind of pose it as this is the predator and they are looking for vulnerable folks that they can exploit. And so, and then also sort of why are these people vulnerable? They're vulnerable because they don't have resources, because they might not feel comfortable going to the police. And then that could also kind of start being part of my like theme and theory of the case about, that exploitation, and also like, trying to get away with it. So I think that's hard to do any training on jury selection because it's so different. But I think you can start in whatever way you have, like laying some of that foundational educational stuff, and also trying to figure out what their biases are. The one thing that I kind of learned though is that I tended not to try to, well, it depends obviously, but I figured that there were a lot of that I couldn't pick a jury of people that knew everything about trafficking. That wasn't going to happen. So I really wanted to pick people that were a little bit maybe more open-minded, that could see like gray areas a little bit more. And so I found myself picking folks that I wouldn't have in other cases, where I wanted, sometimes in other cases, you want like super law abiding, like, you meet the elements, you're good to go. But in our cases, like our victims aren't going to be perfect, right? They're not going to be, they're going to have some difficulties too. So I didn't want somebody being so judgmental that judgmentalness went onto my victim. So kind of figuring out like who would be good. So like I tended to pick like younger jurors that I wouldn't necessarily have picked in other cases, and really was thoughtful about that. And I don't know if anyone else has different theories of picking juries on these cases, but I found that it was a different type of person that I was looking for. Somebody that was a little bit more like eager to learn and to listen, and be open-minded. I don't know. What do you think, Miiko?
I did something similar to that too when I picked juries, because I needed the open-mindedness. And for me, I focused on the dynamic of the overall jury. I didn't want anybody who was too opinionated one way or the other, even if it was on a side that may support me, because I didn't want, how you would have someone then feel the need to argue against that person because they're so dominating. So I wanted to make sure that the dynamic was overall. And in my mind, and this is kind of crazy, but in my mind, the way I would think of it is, do I think that on some topic, no matter how random that topic can be, that like one juror 8 could have a pleasant lunch with juror 9, even if they were talking about paintings? It could juror 1 have something? There had to be like, that Venn diagram. Where was that part? If they all could have something, even if it was unrelated, then I felt like the dynamic would be good, because I would really want to foster, I really wanted a jury that would welcome like communication, discussion, and be able to talk about it, because none of it is really like, there is no slam dunk, like, very rarely do you have like a slam dunk case, period. But when it comes to human trafficking, you don't. You want people who will think it through and not feel the need to stop and argue against another point.
That's really interesting. I like that Venn diagram of like something you can talk about.
There's some, yeah.
Okay, so then I think, opening statement kind of this goes without saying. Although the only cautionary thing I would say is like, I never gave too many details of what they were going to hear because I never knew.
True. And for me, opening statement was like my favorite. I went all in on opening statement. You could not stop me. I didn't commit. So that's why my pretrial motions were so important, because I had to know what I was going to get in. So I wouldn't like disappoint at the end at closing, right? So my pretrial motions were important. So at least I would have these things that I knew were coming in. But opening statement, it wasn't so much fact specific. It was more, that's where I wanted them to connect with the emotion of the case, the tone of the case, the feeling of the case. Everything that I described was painted out really in vivid detail in opening statement, and it made it sound like I was promising a lot, but I was promising a lot on the emotional side of the case, on the either the trauma that was suffered or the things that were leading up to it. But that's where I really wanted everybody on my side. Like, I went in hard on opening statement all the time. That was absolutely my favorite. And I know, like, in some of the instructional manuals, when it comes to opening statement, it starts off with, in opening statement, the evidence will show. I may say that for me, I may say it once in the very beginning, but then after that, it was just straight storytelling, but it all hinged on the emotion and not so much the facts, because I didn't want to do what you were just talking about, like promise some facts and then somebody not show up and then in closing have to be apologizing. But it was always the emotion and the tone, and where I tried to get the connection and why they should care about what was going on.
Yeah, I
I
think
love
that's
opening
where,
statement.
and I wish I had seen one because I can only imagine it now. But I think that emotion is also where you get that empathy, right? To start building the empathy for your victims that might, otherwise, we know how the defense is going to paint them, right? And you can see in the chat, folks are talking about the fact that forced criminality, complicity, culpability, those are things that the defense wants everyone to focus on. Tiffany's talking about, even with labor trafficking cases, the sort of like, well, life is better here. This is still a better opportunity than what you had before. Right? And those are really all very real things that we have to counter. And I think one of our greatest tools for that is to have that emotion and build that empathy. And we've got to be doing that right at the beginning, because then that gives like the glasses that we want them to see everything else through. Like, I want them to be thinking of that emotion as they're hearing maybe a victim that's not so emotional, but they're listening to what you were telling them in advance and maybe even warning them about some trauma stuff. So how do you deal with, because victim testimony sometimes, victims, if they've been connected with services and they've been allowed the time and space to sort of reflect and learn about trauma themselves, sometimes they can be their own very best expert witness. But we also know sometimes we're going to have victims that are not giving us what we really want as far as that emotional piece. So how do you deal with that victim testimony?
For me, I think that's where the expert testimony really comes in handy to explain the way the victim may present in court may be totally different from where the victim was when the crime actually happened, because a lot of times sometimes can pass between the incident and the time we make it to trial. Or even if at the incident, the victim say there's body cam or some video footage or some, some recording of the victim's immediate reaction. And it may not seem like I was saying before, like the fear may not seem the way most people would think fear presents. Having that expert there to explain why why victims behave in that manner, how that is still consistent with someone who had suffered a great degree of trauma. and laying that out. And that would be one of the things that, because I would know that explanation is coming in from the expert before. So that would be one of the things that I would bring up in opening. And so I would say that maybe when the victim will finally, after all of this, I'd paint the picture after all this happened, but when the victim met with law enforcement, the victim wasn't crying. She was, he or she wasn't upset, blah, blah, blah. So I would let them know right there so when they saw it, they would already be prepared for it.
Yeah. I think that expectation setting is another thing that we're doing at all these places. And then witness testimony. I think sometimes, and we'll talk about how law enforcement, especially really experienced law enforcement, can maybe serve dual roles as either listed experts or maybe pseudo experts. But witness testimony can also help us, whether that is somebody that is an eyewitness, or more often than not, it's law enforcement that's able to talk to us through things like, oh yeah, that's not uncommon that somebody would, when I first tried to talk to them, that they would swear at me, or yeah, it's pretty usual that I would not do a really deep interview the first time because I know through my training and experience. And so you can get some of that out through your witnesses as well. Now I'm going to skip expert and go back to it because I think that's where we'll spend the rest of our time. But in closing argument, it kind of bookends your opening statement. But what was your approach to the closing argument? And did you get two?
Yes. So I did the initial closing, defense did their closing, and then I did the final, is how it works in our jurisdiction. So a lot of times I think, and it really depended on the case. A lot of times though, I would spend my initial closing, I would go, of course, through, the facts and how the elements were met through these facts, and do that, show probably portions of some of the most compelling evidence. I would be very careful though to not show, I wouldn't want to sensationalize or unnecessarily show very graphic evidence, right? So those types, if we had those kind of pieces of evidence, I would maybe refer to it or describe it or talk about it, but I would be selective on what evidence I would show in closing. So it wouldn't necessarily be the most graphic of like injury or anything to that degree. So that was like case by case, because I didn't want to have the jury think that I am primarily guided by emotion, even though that there's emotion in the case. So I want to pull them in so they understand the gravity of the situation, but I didn't want to really exploit anything that didn't necessarily need to be re-shown, if that makes any sense at all. So I was selective about what exhibits I would re-show at closing, and I would show ones that needed to be showed. So don't think I didn't do that, but I would be very selective in that. And then sometimes in my initial, I would directly address whatever I thought the defense closing argument would contain. So there would be some times where you might want to hold back so you can rebut, but a lot of times I would just do it first, and then a lot of times defense wouldn't know how to bring it up in a way that didn't already include the counter argument because I've already discussed it. So that's kind of a strategy thing. But that would be it.
Taking the wind out of their sails.
Yes, absolutely. And just, would argue as much as I possibly could, like I said, with being really careful to not overly emphasize like graphic pictures or graphic recordings. A lot of times we had those pieces of evidence, so I could just refer to them without really showing them over and over again.
That's really interesting, because I think instinctually some of us would lead with the most graphic kind of pieces of evidence and really want to have that in their faces as they go back to the jury room. But in your experience, the jury sees that almost as like a play or like a stunt, and you don't want to be like thought of as like somebody that's just living on this sort of drama of it.
Exactly. And I would describe it, right? So say it was shown in trial. So I would describe it, but I would describe it vividly, like I would describe it, but I just may not show it. And I would want them to mentally recall it because I would want to take them there so they could mentally recall it. So I would describe it and then tell them what exhibit it is and it's available for them, you know, to look at. But I would want to mentally take them back there and not just show the picture. Because a lot of times too, when people are confronted, because these are still people, you know what I mean? Secondary trauma is real for jurors too. So a lot of times when they're confronted with a really graphic image, sometimes they look away. Sometimes it's difficult for them to take in. Sometimes they cannot hear what you're saying while the image is up there because it's such a powerful image, right? So that's why I say it's really selective. And for me, it was a lot, it was effective to describe it in detail and then still be able to talk about it and refer to it.
I'm going to take that piece of advice. I think that's great. And you hear about it. I hear about it more in like child sexual abuse material cases.
Mm-hmm.
If they've tried those cases, I've had prosecutors tell me that showing the image, the jurors end up blaming the prosecutor for that trauma that they are experiencing. So it's like a really complicated way that, and then for you to describe it so that they're still there present with you and not looking at this exhibit, they're hearing you and your argument. I think that could be really powerful. Okay, so now let's get to like, you know, what we're all here to talk about, which is the experts and expert testimony. So I'd love for you to share, because I know the story, like some of the how you used expert testimony in your trafficking cases.
Sure. Well, there was more than one case, but the one expert that I relied on that comes to mind is a survivor expert, Rebecca Bender, and she came in to help me with a case where I had a victim who wasn't able to testify. And it wasn't a matter of not being cooperative, and it wasn't a matter of being unwilling. This person was truly unable to testify. She was a minor, and I want to say she was 17 at the time of the incident. She became an adult by the time of trial, but she had really serious psychological effects when it came to the trauma that she had suffered. She had made it through a preliminary hearing, at least my direct exam during a preliminary hearing. And she couldn't make it through the cross-examination. And I can tell you honestly that defense attorney was not being aggressive or egregious. It was just, the whole episode was just too much. And she had managed to muster the strength to make it through my examination. But when it came to cross, she couldn't make it. So what happened was that we had requested, we took a break, and we were eventually realized that we would have to request that all of her testimony be stricken because she couldn't complete it, and they didn't have an opportunity to do a cross-examination. So it was really hugely important because she was a minor and force was used in California. That changes the exposure from a 12-year max to a life exposure. And this particular trafficker had a history of trafficking another minor some years ago, and had used an incredible amount of force and abuse and violence with this particular victim who was unable to testify. And she didn't have any injuries that we could show that violence was used. The digital evidence didn't show that there was any threats or violence because this person had been convicted before. He knew enough to not text anything. Everything was done via phone call, right? So we didn't have any evidence other than her testimony that would explain the amount of force that was used, the violence, the force, the sexual assaults, no evidence of that. No witnesses to it, no evidence of that. So it became really important to explain her absence. So I had the expert Rebecca Bender in that case come on, and she explained victim behavior. She explained um, um, particularly her absence. And one of the things that I think people would be really better served by is that definition of expert. A lot of times people think professor, or they think like a bunch of like, exactly, they think a bunch of other of like formalized education. And
letters after the name.
exactly, exactly. And in this case, Rebecca she had all of it across the board. So like a phenomenal expert. But she could speak to her knowledge as a survivor, the fact that she worked in this industry with so many other survivors, and then on top of that, she had separate education in that area. So she was able to explain some of that victims' behavior, and that coupled with like some other pieces of evidence that we were able to get in, like body cam footage, like just snippets of it to show her fear and force. We were able to be successful in that case, but it was really important because there was, and this particular victim had had a history of so many different things in her history. We had to argue whether or not they were coming in and coming out. There still was enough that my concern was that the jury would not see that this was truly force. Rebecca Bender, she based in California. She is, but she travels. So she is in California. She travels. And I used her in another case where I had a victim who wasn't present.
Yeah, and she does really effective training with law enforcement, and there are a lot of survivor leaders that could serve this role. But I do think, well, first of all, I think it was brave that you were like, okay, the first expert I'm going to go in with is a survivor expert, because if you look at the case law back in the early days, you saw that prosecutors were a lot more comfortable with somebody that had like a PhD after their name, and that had a lot of like academic qualifications and that type of thing. So to look at it, because we're looking at the federal rule, which every state basically mirrors this. There's no reason why somebody that doesn't have that experience, knowledge, specialized kind of experience and knowledge, why they wouldn't qualify as an expert. But Rebecca is also the first one to tell you, I'm not an expert because I survived a fire. That didn't make me an arson expert. She's an expert because after her experience, her lived experience, she has built a career working with other victims, and she runs the largest online school for survivors, and she teaches, and all these other qualifications. So I think it's important to recognize that as well. But I'm sure that the jury, sort of loved hearing from her. I always find that, they connect with folks that have, that experience providing direct services. They love nurses, like academics, there's definitely a place for that, but somebody that has that real life experience working day to day with that population, I think can be a really effective expert.
It can be, and I think and that's exactly right. Rebecca had so much, and there's so many different survivor experts, or I don't know if the better term is lived experience experts, that have the layers of knowledge, right? So it's not just one avenue that can be so helpful, but it was like the jury was locked in to her every word, because it allowed them to see, if anybody in the jury had any question before, that there is nothing so completely foreign about a victim of human trafficking, right? The idea may be like something that you don't run across or some experience you've never had, but the actual, when you break it down to a human level, it clicked. If it didn't click before, and hopefully it didn't take that to click, but if there was any hesitation, it clicked because she was able to clearly paint, the type of vulnerabilities, the behaviors, why certain things, why certain responses took place. in a way that made it understandable to somebody who maybe had absolutely no connection to this type of subculture at all.
And you've also used law enforcement as an expert. And we talked about the fact that sometimes we use them as like a pseudo expert. You actually have had law enforcement deemed an expert and then had them testify, folks that were not
Yes.
involved in your case.
Yes, and I would find law enforcement that, an expert law enforcement officer that was not involved in the case, because I didn't want anybody, I wanted that separation and an additional, kind of neutral approach to what they were testifying about. And I would use in human trafficking cases law enforcement experts, and I would have them recognized as an expert to talk about the subculture, terminology, trends, and certain behaviors that that they saw as law enforcement officers for expert testimony. And what would happen is the law enforcement officer with the a survivor expert, law enforcement expert and a survivor expert would sometimes testify and bolster each other, because they would define the terms as exactly the same, or some situation as exactly the same. So it worked in a way to both support each other's testimony too.
Yeah, I thought when we talked about this in advance, I love that idea, because one of the powerful things about using a blind expert, that expert who hasn't met your victim, doesn't know the defendant, hasn't read any police reports, you make that clear in their testimony. One of the powerful things about it is that more often than not, their testimony totally lines up with your facts. And you make that argument later on. And the jury's like, they had no idea what this case was about, and they still sort of nailed these things that came out. And then add upon that not only does your expert on victim behavior line up, but then your law enforcement expert is also lining up. You're kind of getting, again, just sort of like through that testimony, it's like, okay, so this is not like a one-off, like this is common. Nobody knows this case, and they're still saying all the same things, and they don't know each other necessarily either.
Right.
So I think we just answered Tiffany's question, that you've used them in the same trial, one sort of for more specifics and then one for more of the emotional piece.
Yes, same trial.
Yeah. So blind expert, we've got a ton of case law, a lot of federal case law. We can do state specific statutory and legal research for anyone on this call that's interested. But really, the promising practice and what we see is going to be the safest way to introduce testimony at trial is through that blind expert testimony, where they don't know the specifics of your case. They may know, like, in preparation, you may tell your expert, hey, I'm probably going to focus on, we're going to talk about terminology. We're going to talk about common, methods of control. And then I want to talk to you about, somebody that leaves and then returns to the situation. I might want to talk to you about that. So you give them like a topic, but they don't really know the facts of the case. And then a consulting expert, and you've used consulting experts too, which is somebody that you're using kind of more as you're, making your charging decisions, prepping for trial, and not necessarily at trial. How does that work, Miiko?
That's correct. And that really helps to have a relationship sometimes with that expert, so that you can communicate back and forth with some amount of ease. Consulting experts, so, is something that I very rarely use. I think I've only done it once or twice, just because I like the appearance of the blind expert and to not have any communication. Sometimes, though, the consulting expert, if you really need that amount of insight right there when you are really kind of like analyzing the case, that's huge, because it's not something that you can get anywhere else. So that's really where I use it.
Yeah, that's when you have a case that you might not even understand. Or you
Absolutely.
think, you think you might get something and then you're like, well, I've never actually heard this term, or I've never seen it work out this way. And sometimes it's somebody you hire, or sometimes if you're working in like a multidisciplinary team, like the ECM task forces, then you just would reach out to one of your partners, probably likely a victim service provider, and be like, hey, hypothetically, if you heard X, Y, and Z, like what would you be thinking about it? And they'd be like, oh, well, that's probably because of, or they would help walk you through that, and it wouldn't be necessarily somebody you were hiring.
Yeah.
But again, just as you said, not to assume our jurors know anything. I think prosecutors are not super great at admitting that we don't know everything. In even, I think, early days, I was like looking at ads and looking at text messages and just like thinking I could figure it out myself, when in reality, we have people that we could probably reach out to and help us like translate some of this. Whether that's law enforcement partners, or if we're working really intentionally with those with lived experience, or victim service providers. So that's sort of your consulting expert. A fact witness who is also an expert. The way this usually comes to mind for me is like a medical professional. So a sexual assault nurse examiner, somebody that's examined, done a medical exam, they're going to testify as a fact witness to the exam, to their observations. And then you're also deeming them an expert so they can give their opinions that their findings in the exam were consistent with, a sexual assault, or a cigarette burn, or maybe something like that you might have there. In labor trafficking cases, it's really important also to provide those victims with medical access to medical care, because they may have expertise related to malnutrition or dehydration that we often will see as a medical consequence of labor trafficking. So I always like to plug the value of our medical experts beyond like DNA collection, which of course is something we think of first. And then the pseudo expert is what I was mentioning, and how I often would use the law enforcement folks. So it would be a law enforcement officer that was involved in the case. I wouldn't necessarily have them deemed an expert, but I might ask them questions based on their training and experience to elicit some pseudo expert testimony. So for example, when I kind of alluded to it, something like, officer, how many times did you interview the victim in the case? Like 4 or 5 times. Okay. Is that common in all of your cases that you're interviewing victims? Like, let's say of a burglary, 4 or 5 times? And they'd probably be like, no. And I'd be like, so tell me more about like why you do that in these cases. And usually you could elicit, with preparation and letting them know that you're going to do this, you can elicit those experienced law enforcement officers to talk about how trust has to be built, how rapport is hard to be built with victims of trafficking, why that might be, why that trust might not be there, how trauma can impact memory. And you can get some of that in through that pseudo expertise. And then of course, also sometimes it's just like operational stuff. They may need to explain what an in-call is or an out-call. And you don't necessarily need to deem them an expert for all of that, unless you're really kind of diving in a little deeper, which it sounds like, Miiko, you were doing with your experienced law enforcement officers.
Right, right. Because this officer had absolutely nothing to do with the investigation of the case. So I needed him to just go over a lot of the terminology and subculture.
Yep. Okay, so we talked about that. Now, I don't think defense attorneys frankly know what to do. And ironically, and I don't even think I told you this, Miiko, Rebecca testified in a case in Dallas yesterday. So I was like, hey, we're doing this presentation. How did the defense, approach you? And she said the defense didn't ask me any questions. So I don't think they know what to do yet. What have you seen them? How did they approach the experts in your cases?
Let's see. It's either to attack the level of expertise that the expert has, to focus on like those traditional ways people think of an expert, to focus on, like you said, the letters behind the name or the absence of letters behind the name, that to focus on any financial benefit that they think the expert may be receiving for testifying, so that bias type of attack, but nothing that really addresses really the content of what they are testifying about. So just kind of those kind of outside things.
Yeah, and those of you that are on the call, I'd be curious if you're seeing any trends, because this is something that I think at some point the defense bar is going to come up with some better plan. But right now, I agree that it's usually attacking their credentials, or questioning their expertise. So, you don't have these letters. And then, there's another issue, which is, before the expert's even allowed to testify, what is their arguments against them even being allowed to testify? And that's usually in two ways. So, and I probably should have had this in here too, but I have seen it. They're either going to say that it's not relevant. And this does sometimes happen where a court will say, like, this expertise only becomes relevant after the victim has been cross-examined. And so it comes in through a rebuttal case. I've seen that. There's some federal case law that supports that out of DC. But generally, it's like questioning the expertise and questioning neutrality, which would be either the pay, which of course, the prosecutor usually asks that during their direct. So again, taking the wind out of the sails, or, the prosecutor will, if they don't do it in their direct, sometimes like you only testify for the prosecution, and then, a defense, a good expert, if they're prepped, will probably be able to say something to the effect of like, but I would testify for anyone who asked, because I don't know anything about this case. So that would be a good way to rebut that. But yeah, I haven't seen anything much better than this. There's been a couple of attempts to bring in a defense expert. I'd be curious if anyone has actually heard a defense expert testify. I have only seen defense expert reports being filed and then them not actually being used. And one of the ones that I've seen a couple of times is a former like ICE investigator who investigated fraudulent marriages on behalf of ICE. And that person has been listed in some labor trafficking cases, but never actually testified as far as I know. So again, something we're kind of trying to keep our eyes on. So you guys in the field learn anything, I'd actually really ask you to share with us. So like, how do you prep with somebody so that they are, because most experts like aren't used to being deemed an expert in trial, and it can be very nerve-wracking. So how do you work with the expert in advance, Miiko?
Ideally, if they are located, in a way where it can work out, if we could meet just to go over kind of really logistics as to when I would call them, why they would maybe be delayed, or that type of I'm sorry, there was a noise, or that type of a situation. And basically for me, the way I would prepare with the expert is all of their materials, right? The things that they maybe have produced that help, help them qualify to be an expert. I would look through those, and if I had questions about any particular thing, I would, address those questions when it came to that, and then from there on, and just give them a real, really just, detailed expectation of what I thought we would cover, like the topics, how you mentioned before, and how long I thought the testimony would take, and maybe give them the name of who the defense attorney is if they wanted to do any research on their own regarding that defense attorney and that judge. But that's pretty much where I would spend the majority of my time prepping with a blind expert who was going to testify.
Yeah. because there's that balance of you really don't want to give them too many details about your case because, they're a blind expert, but you still want to give them like a little bit of a heads up about the topics that you want to cover. I would say, and we do a lot of training here at AEquitas where we match up like would-be experts with prosecutors and do training where they're together for the sort of the legal piece of it. And then we do some mock expert testimony, but basically going through credentials, but also prepping together and all of that. But I think one of the lessons learned in prepping for these cases is not only to be asking some questions, but to be listening, because I learn something new every time that I talk to an expert or talk to somebody with lived experience or talk to somebody that is a sexual assault nurse examiner. Like they're always teaching me something new.
And I agree with that. To me, one of the many ways you can learn like really detail and get a lot of insight in these cases is to work really closely with people in other disciplines and other histories. So the idea of a mock examination with an expert on a case, to me, that's I wish I would have known about that when I was prosecuting cases, because I would have done that in a heartbeat, because that it's the kind of experience that you cannot recreate other than to actually do it, and to do that and then be able to have discussion about it is huge.
Yeah, and we'll kind of do a shout out that we do have some examples of testimony that we have transcripts of. So that's something that we're happy to share with folks on the call. But really, it's this idea of coming up with a roadmap so that both the expert and yourself are comfortable with like how your testimony is going to be developed. And so this idea of like an introduction, going over the credentials, talking about the experience, and then sort of then walking into the actual expertise. And this is another thing that I have seen is that sometimes defense attorneys will try to stipulate and say like, oh, I stipulate to their expertise. We don't need to go all the way into their credentials and experience. I think most of us probably know, but like Miiko, do you ever allow them to do that?
I do not. We want to go into every bit of history that they have that establishes them as an expert, because the jury needs to be really confident in their testimony. So absolutely, I never stipulate to the expertise of an expert witness.
Yeah, and I
Because
think
I would hate.
legally the argument is that the jury decides whether to believe that person is an expert or not. And courts kind of go through different processes. In Florida, while I was practicing, we changed it. Judges no longer like deem them an expert in front of the jury. And so it is up to the jury to decide whether they're experts. And so, there is no kind of stipulation. So you shouldn't have any pushback on that with your judges. And then the idea is like, okay, we have some organized areas of expert testimony, and that generally questions go from like broader concepts to more narrow concepts, including some maybe overlay with the facts of your case, and then kind of end. You can start here too. This is literally just an example of how to maybe roadmap it, is to then establish that neutrality by ending with, would you talk to the defense, or do you know anything about this case? Do you know the defendant? Like those kinds of questions at the end. So we do have like a little bit of what we call our funnel style of expert testimony. And again, this is something you can play around with and figure out like what works for you. I always like this because it helped me become organized without having to have like a script of questions, because I always felt like if I had a script, I'm not really listening to the answers. I'm waiting to ask the next question. So if I could just give myself topics, and then with each topic, I already kind of knew how my questioning was going to go. Like, hey, Miiko, like, are you familiar with the concept of delayed disclosure? Miiko would be like, yes, I am. Okay. Can you just briefly tell the jury what I mean when I say delayed disclosure? That's, when somebody doesn't report to the police immediately. Okay. And then I would say, like, in your experience, is it common or uncommon if that somebody delays reporting to the police? That's super common. And then I'd be like, okay, so what are some of the reasons why somebody might delay? And at that point, the expert, now I'm just putting Miiko on the spot here. Miiko could list like 10 different reasons, right? Well, fear of the perpetrator, fear of the unknown, fear of like everybody finding out their business, distrust of the system. Like she could list forever. And then I would then say, okay, I'm thinking about my case. In my case, my victim didn't report because she had a criminal history. So then I would say, would it impact, in your experience, would it impact somebody's ability to disclose to police if they had a criminal history? And then Miiko would be like, yeah.
Absolutely.
Yeah, because they probably had negative experiences with the police and maybe they don't think that's a safe place to report. That would make a lot of sense. So going from like the very broad to like the very specific. So we've got like an example for you guys here about this idea. In this example, we use the concept of like choosing up, which I think is one of the more difficult concepts to explain because, of course, intentionally, it seems like the language is very voluntary, or it's made to have others believe that this is a choice, where one maybe leaves one trafficker and chooses to go with a different trafficker. So are you familiar with this concept? What is it? Why might a victim of trafficking decide to do this? And then would it affect the victim's decision if there was a really violent situation that they were trying to, yes, this is a situation of trying to lead, the best of two evils or the better of two evils. So that would be kind of just the flow of that conversation.
And I can tell you when Rebecca testified in one of the trials, the attack from defense was mostly on her expertise. So just as you have it mapped out here, what I did though was, are you familiar with this concept of choosing up? Then from there, just how are you familiar? Because she had so many different ways she was an expert, I would have her highlight each one. So because of her personal experience, then she would talk about the experience that she had when she worked with the survivors that she's worked with. And we talked already about how many she had worked with already. And then from there, then what about formal education? Because she has taken and taught so many different courses on that included that concept. I would separate it a little bit just to hit the point that the defense was trying to make when it came to her level of expertise, that just because she had been through it, they tried to really narrowly define her as just, and I don't want to say just a survivor, but that was the only basis for her knowledge when it was not.
So you're sitting there going, you're familiar because you personally experienced it, because you've worked with hundreds of other women that have experienced it. So personal experience, working with others, and then also attending and giving trainings on topics related to this as well. So you're hitting it 3-4 different ways. I like it. Yeah. And then the sort of last thing I think before we kind of wrap up and maybe answer some of your questions is the use of demonstratives. And I know that Miiko, you didn't actually ever use them in trial, but I'm sure that you use them at sort of prepping for trial. We have 3 possible demonstrative exhibits that I've seen successfully used. I think ICP may put some links in the chat here. One is the power and control wheel. I'm sure you've all seen it. Sometimes that can help you organize your direct examination of the expert, because you can kind of work around the wheel and say, okay, let's talk about the spoke of isolation. Are you familiar with that? Traffickers using isolation to assert power and control. Yes. How was that done? And then that kind of just gives you an opportunity to organize your direct examination by going through the wheel. Similarly, the Biederman's chart of coercion has not only the different tactics, but then the effect of each of those tactics. So that can be, and you can just put these on like PowerPoint slides and have the jury look at them at the same time the expert is sort of walking through them. And then the other one that I'd point out that I haven't seen used yet, but for labor trafficking, it could be really helpful. It comes from Urban Institute's study on labor trafficking in the United States, and sort of delineates what are the tactics that are like labor exploitation, and then some of the tactics that more match up with labor trafficking. And I think that's one of those things that for labor trafficking cases can be a more complex thing to explain. Not every bad job is labor trafficking. So they've got a chart in there and some examples of the tactics that kind of cross over from this is an administrative issue for DOL, wage and hour, and this is something where it starts becoming criminal. So that's another demonstrative that might be helpful for you. So we put those all in the chart. And like similarly, you're going to ask questions that kind of go from that. I'm showing you this exhibit. Do you recognize it? How do you recognize it? How is this used? How have you used it? And they might say, like, I use this to talk to victims. I use this in trainings. I use this to guide interviews, whatever that, and then kind of go spoke by spoke through that. And in this example, we started on isolation and then did an overlay of how might isolation be impacted when the victim does not also speak English. You're like, well, isolation would be even a stronger tactic because that idea of being able to reach out for help when somebody doesn't speak English is even, a more difficult kind of thing to accomplish. So that's kind of the, a model of how you might want to use those. They put them all in the chat. Thank you, IACP. Wanted to kind of open it up to you guys if you had any questions. So start thinking about those questions. But as you guys are thinking and typing those up, I wanted to ask Miiko for any sort of final thoughts or tips you have for the prosecutors out there that are thinking about or trying to use experts in their cases.
That really, I really found it to be very effective to have survivor experts to, excuse me, give you a level of insight that I don't think anyone else can give. So to definitely consider that. And then if you are working in like a multidisciplinary task force, or if you have other stakeholders, other partners that you work with, just to remember that they truly are experts. And so to acknowledge that and then develop those relationships so that you can have, if you need that consulting expert, right? If you need that information, to have it and make it so it's not necessarily sometimes involving a case, that it may just be a topic that you need to learn more about. So that way you already have a higher level of knowledge when you come to trial and you have a similar issue.
Yeah, absolutely. I think we don't use the expertise, we don't like leverage that expertise that we just have in our communities and our partners. And some of that is, the role of the prosecutor. I don't think we often give ourselves enough time to learn and just sit there and be like, let me learn about this topic before I have to try this case. And there's lots of reasons for that. But I know that when you started doing trafficking work, you really gave yourself that runway to go, okay, let me go to some trainings, let me teach myself, let me learn this so that I can do this effectively. And I think that's important for us all to think about.
Right, because you do want to be in one of the experts in your case. So you want your judge and your jury to rely on you, but you want them to do it confidently, and you want to be confident in how you present the evidence. And the only way you really get there is to work through a lot of the concepts and and experiences and try to understand things that you may not be familiar with, or a deeper level of understanding. So really, to be an expert, you just have to go through it, and then you'll find that in that process, because you have to rely on other people to give you the information, you walk away with like meaningful relationships, people you can really turn to, and you walk away with at ease when it comes to the conversations, and to be able to really articulate difficult concepts to different types of people, because we can all sit in another prosecutor's office and talk about a case, but sometimes that's not who our audience is.
You're reminding me of when I first like got a job as a prosecutor. And I looked at my background, they're like, you used to be a bartender. How is that going to help you? And I literally said, you know what? Bartending was so key because it made me have to talk to different people. Like they just came into my bar. I had to talk to people from all different walks of life on whatever topic they wanted to talk about. And I think like not everyone needs to go out and become a bartender, but I'm just saying like that concept, although it's a lot of fun, that concept of honing your skills on talking to people, not your colleagues that are lawyers and doing all this, but just like your potential jurors. Like, how are you planning on talking about labor trafficking? How are you planning on talking about non-physical coercion? And where are some opportunities you might have to like practice that conversation? I was thinking about Tiffany's comment of, you know, the migrant plight. If you've got other folks on your jury whose family history is of migration and of like, you know, just, I don't know, sucking it up and doing hard things and working 5 jobs. Like, why is labor trafficking? Like, my parents did this, my grandparents did this. Like, you just kind of have to put up with it to, you know, get where you want in life. How are you going to kind of combat that at trial? Like, how are you going to have that conversation of like the American dream, you know, turned into the American nightmare? Like, I feel like you can do some thematic stuff, but you can't just assume you're going to walk in and make your case based on the facts of your case. You have to be prepared to win those hearts as well as those minds. And that takes practice. And your experts and your partners can probably help you with that. So feel free to add any questions. We've got the evaluation here. It's a QR code. I know that IACP would really love your feedback, as would we. This is, like we said, the first of a series. We want them to be conversational. We're going to, you know, try our best to make them interactive. But right now we're kind of dealing with, you know, working with the chat. So dependent on you guys adding things in there. So Tiffany's asking of a survivor expert for labor trafficking. And we are trying to build capacity within that field. I have a couple of ideas of folks that might be willing to do that. But again, labor trafficking can be really different based on venue. Like, you know, domestic servitude is going to look different than agricultural migrant work. So we can definitely think through that. And I have a couple of ideas that I'd be willing to play around with. Don't want to put them out here when I haven't had a conversation with them yet, but reach out, because I think we are, as a field, wanting to build that up. As more and more folks are focusing on labor trafficking, I think it's important for us to have some experts kind of, you know, have them feel comfortable, because there are experts out there. It's a matter of, you know, building that capacity and having them feel like that's a comfort level for them to be doing. So working on that. Shay, I see you're up there. But we're going to close it out. There's again our evaluation, all the contact. You can reach out to IACP directly. I don't think I put my contact information here, but a lot of you know how to get a hold of me, and I'm happy to put it in here. But we're going to have our next conversation, which is sort of capturing the totality of the trafficker's criminality. So looking at co-occurring crimes, how are we going to really make sure that we're putting in front of the judge and the jury, like all of the sort of bad acts that an offender's doing. So whether that's using different charging or using a 404B strategy. And that conversation will be with David Weiss. He's a prosecutor out of Brooklyn. And that'll be a great one. So please join us for that on December 14th.
As Jane mentioned, we would love to hear your feedback on the evaluation. Thank you everyone for joining us today.
Thank you.
Thanks, Miiko.
No problem. Thank you.